Welcome to LexIcon, your visual guide to public international law. During the last lecture, we were speaking about the formal criteria of statehood, which are permanent population, defined territory, government, and the capacity to enter into international relations. Today we will speak about the attitude of other states and governments to the formation of a new international entity. Therefore, we'll speak about recognition. More specifically, the topic for today is the role of state recognition a must-have or not. Recognition is a unilateral act whereby the government of one state officially acknowledges the existence of another state or government. The topic has traditionally been quite complicated for two reasons. It's impossible to strictly detach law from politics, or to detach the legal aspect of recognition from its political aspect. And second, it is not entirely clear what gets recognized. Is it the state as a single entity, or is it just the government of the state? However, the topic is also very significant, at least for two reasons. Politically, recognition shows that the existing states are willing to welcome a new member of the international community. In a way, recognition is a welcome drink in international relations. And second, legally, recognition shows that a new state has fulfilled the legal criteria of statehood. Let's now take a look at the Montevideo Convention on the rights and duties of states and see if it contains anything on recognition. Article 3 provides that the political existence of the state is independent of recognition by the other states. Even before recognition, the state has the right to defend its integrity and independence. Later, Article 6 provides that the recognition of a state merely signifies that the state which recognizes it accepts the personality of the other. And then it provides that recognition is unconditional and irrevocable. Let's see what that means. Recognition is unconditional, means that one state either recognizes the new state or doesn't recognize it. It cannot set a condition for recognition. Recognition is irrevocable. To revoke means to declare that something is no longer valid, to cancel, or to take back. In this context, recognition is irrevocable means that when a state recognizes a new state, it cannot take the recognition back. However, this is just a Montevideo look at the problem. Is there anything else relating to recognition contained in other international legal instruments? The Covenant of the League of Nations, the predecessor of the UN, or the Charter of the United Nations contain no express references to recognition. However, international legal scholars have developed two theories. One is constitutive theory and the other is declaratory theory. Let's examine them one by one. The constitutive theory provides that an entity that claims statehood actually becomes a state when it gets recognized by other states. The core of the theory is that approval of all members is required, and it's closely linked to the notion of consent. Let's see how constitutive theory works in practice. So we have the permanent population, defined territory, the government that controls both the territory and the population, and the capacity to enter into relations with other states. So this is an entity A that claims statehood. Based on the constitutive theory, the recognition by other states would be required, and only then entity A would become a state. The declaratory theory provides that an entity that claims statehood becomes a state when it fulfills all criteria of statehood, and recognition is merely a declaration by other states. In essence, when a state exists, it is independent of the will or the consent of other states. Let's see how declaratory theory works in practice. So we again have the permanent population, the territory and the government, and the capacity to enter into relations with other states. We have the entity A that claims statehood. According to the declaratory theory, this entity A is already a state, and recognition by other states would be optional. Thus, constitutivists say that recognition allows the new state to effectively enter into relations with other states. They provide that non-recognition might indicate that the state was formed not in compliance with international law. Declaratorists, on the other hand, provide that existence of a state is a legal but also a factual phenomenon. When the state exists, recognition is not mandatory. Declaratorists provide as well that recognition or non-recognition are usually political decisions. We have to make a distinction between de jure recognition and de facto recognition. De jure means legitimate, lawful, or stated by law. De facto means as exists in reality, in practice, or factual. So what is the difference between them? De jure recognition happens when the state recognizes the new government as legitimate. De facto recognition takes place when the state recognizes that the government exercises control, so this relates not to the legality but the existence of the government. One does not exclude the other. De facto recognition usually comes first and then de jure recognition follows, but interstate relations may already exist at the point between the two types of recognition. There are also two forms of recognition. One is express and the other is implied. Express recognition is made by a formal declaration. It can be a diplomatic note, an official announcement, and so on. Implied recognition is made by means other than a formal declaration. In fact, contrary to the Montevideo Convention, nowadays it is accepted that recognition may be conditional. A condition such as disarmament and nuclear non-proliferation may be set. However, de jure recognition is indeed irrevocable. When a state de jure recognizes a new state, it cannot withdraw the recognition. So what are the effects of recognition? It does not change the legal personality of the state. It doesn't confer legal rights or obligations. So it doesn't have so much of effect on the interstate level. However, recognition may affect the lives of individuals. For example, a question of whether passports issued by a new state are accepted in other states is exactly the question that may be relevant here. And here we come to the eternal legal dilemma. One school of thought provides that without recognition, state is still a state, and the other school of thought provides that without recognition, state is not really a state. Lawyers and legal scholars tend to prefer the declaratory theory. However, it looks like in practice, the constitutive theory is somewhat stronger. That was it for today. I hope you liked this video and found it useful. If you have any questions, leave them down below, and I see you very soon.